Good morning. All right. Okay, Ms. Korndike, welcome. This is your motion for a show cause hearing. We're here in the matter of Ensing versus Schmidt, case number 22-03489 DC. What's going on, ma'am?
Yes, so I'm covering for Ms. Smulders today. We filed this motion because there is an order that when the parties communicate on Our Family Wizard, it's supposed to be strictly about the child. And
Right.
There's been some stuff being said about my client specifically that I think falls outside of the purview of being about the child. Some derogatory things like that. There was another one after we filed of him calling her an evil manipulator.
Isn't this going, isn't this stuff going through My Family Wizard or something?
Yes.
Okay.
It needs to stop, Your Honor. Like it's outside of the scope of what they should be communicating about. There's no reason for that. If they have issues, they have issues, but it should be about the child strictly. And
Right.
So that kind of behavior just needs to stop, Your Honor.
Sir, what's your response? I've read your response. What do you have to add to it for the record?
Honestly, I think that Marissa's frustrated that I'm finally making headway, getting some more time with my child. I finally got vacation time. I think she's just filing petty litigation, and I don't think this is.
I don't know if there's enough to hold you in contempt here, but there's enough that I can look at you and say, knock it off. I mean, these communications don't have to be at what they are. You need to stop. You know, my problem, Ms. Korndike, is a lot of these communications are within parenting time requests and confrontations. Yes. But this is not for confrontation, Mr. Ensing. This is for communication.
I understand.
And you are becoming somewhat confrontational. And I realize it's in the context of you asking for parenting time. But there is no necessity for name calling or, just being blatantly obnoxious. But, just because he's being a jerk on these is not enough at this point for a contempt hearing. But it is enough for a warning to say, Mr. Ensing, when you're talking to her, you're talking to the mother of your child. Talk to her as such. Ma'am, vice versa. You're talking to the father of your child. And you're right. You should be upset about these. This is unnecessary, Mr. Ensing. And no, this motion was appropriate so that you can come into court and be told, grow up. Okay? So to that extent, I am enforcing the inherent rights portion of the judgment and the statute, which means neither one of you is supposed to disparage each other. That is inherently illegal. It's part of the statutes of the state of Michigan. So when you get that stupid, luckily, I don't think you crossed a line. I've seen a lot worse, Ms. Korndike, forgive me, in comparison. But it's appropriate to bring it in to say, admonish you and say, don't do this. Because you're going to be coming back here, and the next time it may be enough for contempt, especially now that I've warned you. Okay?
Understood.
Make your requests. If there's a no, either bring it back to court if necessary or work through it. If there's a yes, great. I mean, I didn't choose the parents here. Both of you did. You're going to be living with each other for a long time, hopefully. Okay? So, Ms. Korndike, as to show cause, I'm denying the contempt, but I am saying that this was appropriate for a warning shot. Okay?
Okay, yes, I'll draft an order.
Okay, no problem. Good luck, everybody. Thank you.
Thank you.
This courtroom opens with tension thick enough to cut through. The judge begins calmly, but as soon as accusations of name-calling and manipulation start flying, you can feel the air tighten. The father tries to defend himself, but the judge wastes no time setting boundaries, reminding both parents that this is about their child, not their bitterness. And when he looks them dead in the eye and says, grow up, the entire tone shifts from irritation to authority. This intro sets the perfect storm of respect, control, and judicial power.
Okay, Mr. Quinn, you connected?
I can hear you loud and clear, Your Honor.
All right. Ms. Palazzolo, you connected? And Mr. Palazzolo, you connected? Good.
Yeah, yes.
Right. We are here in the matter of Palazzolo versus Palazzolo, case number 23-10327DM. Ms. Van Dyken, you are here on behalf of Mr. Reams, who filed this motion. What do you have to add to this motion, ma'am?
Your Honor, simply that I believe that he meets the threshold for Shade be right with regard to the parenting time. Mr. Palazzolo has changed his work completely in order to
Yeah.
be available. It benefits not only him, I admit that, but it also benefits the child, not having to be in daycare or having an au pair or a nanny, transportation, and it also benefits Miss Palazzolo. Let's not forget that she is, I agree, the primary physical custodian, but she would want her child to have a better relationship and a long-standing relationship with the father. So I think the court should set this matter for an evidentiary hearing so where it can hear the evidence with regard to the best interest factors and go from there. Thank you.
I guess let me set this up. So he changes his job, but he's doing the same type of work, correct?
Independent contracting, Your Honor, no longer.
But he's, yeah, the
hours.
hours are different. There is nothing in the judgment that ties it to his parenting time to the job other than the fact that he might lose a weekend because he has to work that weekend. So, yeah, I'm afraid that looking at this, no, what's going to do the child better is if these parties stop the continuous litigation. It's getting ridiculous. There shouldn't be 4 files on a case that's only a year and a half old. This is absurd. So no, this judgment was just entered 6 months ago. We're going to finally let the ink dry on something in this case and let it solidify. And you might be putting words in Miss Palazzolo's mouth about, I'm sure she wants that relationship. She did. They negotiated this. He's got parenting time. That was already set. It was put in order. It was put in a judgment in October. So 6 months ago, we're done. No, we're going to let the ink dry on this and the litigation needs to stop. That will help the child. Yes, Mr. Quinn.
Now things heat up fast in the second case. The father's lawyer argues he changed jobs for his kid, but the judge instantly sees through the excuse. He's had enough of these endless motions, calling out both sides for turning family court into a battlefield. His voice sharpens, his patience cracks, and his words cut deep as he says, "Land these helicopters and stop this litigation." It's not just a ruling, it's a reality check. This moment captures how the courtroom shifts from fairness to firm authority when games replace genuine parenting.
I don't have anything to add to the substance, seeing how the court, I think, has already ruled and denied the motion. Our only request would now be for attorney fees for having them bringing this motion.
Yeah, no, I like I said, you guys got so many things in the works on this. No, not at this point. Again, you guys both need to land these helicopters and stop this litigation. Good luck.
Okay. I'll prepare the order, Your Honor.
Yeah, move on with your lives, please. Thank you.
Thank you.
Good morning, everyone. We are here in the matter of Massey versus Massey, case number 25-01127 DM. We are here to amend a temporary order. Ma'am, Ms. Pelto, I've read your request. Sir, what is your response to that request?
Your Honor, I would like this motion dismissed, just due to, there's a hearing on June 17th with, Judge DeLange.
Right.
I feel that I've abided by the court orders, and I have moved within my 100-mile radius.
Uh-huh. And you made it almost impossible. Do you guys each have a vehicle now?
I'm trying to remember what date it was, but last week.
So she was ordered to do a lot of the transportation, if not all of the transportation, and you moved so far away that now she's got to pay all this gas and all this other stuff, and you guys only have one vehicle that you can barely afford. That's why the judge set up the other thing in any event. So you choose to move away and have this kid spend over an hour in a car. You've had this great parenting time, both of you did. The judge worked it out, and then you choose to move so far away that you make it impossible.
No, Your Honor. May I say something, please, Your Honor?
Sure.
So what had happened was I was going to finish my lease out in Grand Rapids.
Mm-hmm.
And I told friend of the court that when we had our recommendation, when Miss Massey got locked up for her domestic violence, there was a no contact order that was put in place.
Right.
And I did depend on Miss Massey for a lot of things. And with that no contact order, it really made it hard. So I moved closer to family that would help me, with the kids while I was able to work. And also,
Where is your job?
I work for PTS Refrigeration.
Okay, and where is that located? Where is your job? Or you drive around to houses and stuff?
It's located in Howell, Michigan, but I'm given a company van where I am dispatched from my house.
Okay, and is that the job you had when the initial parenting time was issued?
No, my hours got cut, so I had to change jobs. It was during that time.
Okay.
April
Yeah.
14th, I did update my address and my
Right.
employment with friend of the
Okay.
court.
All right. What hearing is set for June 17th, Ms. Pelto? Is this going to be a divorce trial?
It's a settlement conference, Your Honor, at that point.
Okay. Yeah. Sir, I'm afraid you've made an impossible situation. I'm granting Ms. Pelto's motion, but it's a temporary order still. You guys still have the ability to maybe get this back to where it was. But for now, because of the impossibility and how far you moved, I know you moved within the 100 miles, but you still kind of pushed that one. So no, at this point in time, I'm going to have no choice because of the impossibility of making this occur, that for temporarily until you get to that settlement conference and a divorce trial, I'm going to have to grant Ms. Pelto's motion out of necessity for now. Okay?
Yes,
Good
Your
luck,
Honor.
everybody. Have a good morning.
Thank you, Your Honor.
And now for the final case, where things get emotional and complicated. The father insists his move was necessary after the mother's domestic violence incident, but the judge isn't buying it. He lays out the cold truth. The move made shared parenting nearly impossible, the travel unbearable, and the child's well-being secondary. You can feel the weight of responsibility as the judge grants the mother's motion out of necessity, not favoritism. It's a sobering end that reminds everyone that decisions have consequences. Don't forget to like this video, subscribe to the channel, and we'll see you in the next one.